Start streaming. Go live. It is on our page,
Perfect.
and I think we're live.
Hey, good morning, everyone. I'm Chris Parker. This is Kristen Ishihara. We're here at the Ishihara and Parker Law Firm here in Longview, Texas. And we have an exciting topic today. One that pops up frequently is how do we handle situations where we have minor beneficiaries? We see people come in all the time, mom and dads, they're living a family, they're raising a family, and they've got very young children. So, Kristen, oftentimes you see people, they come in, they get a scenario and say, don't worry, we've got it solved. I named my 5-year-old child as the payable on death beneficiary of my bank account.
Yeah, easy answer. Don't do that. But I think just more globally for young families, we want to talk about, too, like what are your specific estate planning needs? Because a young family, you've gotten married, you don't have anything at all. You've started working at a job, you probably filled out for their HR or life insurance or 401k paperwork. And now you're, 5-10 years down the road, happily married, have some kids. You do have some estate planning needs that you probably don't realize because, of course, at that young age, you're not thinking about what happens when I pass away. That doesn't happen until you're closer to retirement. So we just want to help highlight some things that we want to make sure you're thinking about. You need to have those conversations with your spouse and usually come to an agreement about how you want to set that up. But number one is don't ever list a minor child as a beneficiary on anything. A minor child's name should not be written down on any of your paperwork ever.
Yep. Well, let's just talk about the why of that. Let's just say it happens. Someone passes away. The life insurance lists little Johnny, right? What problems, what will be the steps, what will happen?
Yeah, so let's say, for example, young married couple have 2 kids that are minors, husband passes away. Now, wife, who, is obviously grieving because their young family, I assume is going to be an unexpected death. If that husband has no will, she's going to have to file a determination of heirship. That's a probate proceeding in the local county court. Then, if he has listed, let's say, those minor beneficiaries as a beneficiary on his work life insurance or whatever it is, now she's got a probate proceeding that she's got to go through. That's $4,000 to $5,000 probably. Now she's got to have a guardianship for each individual child. Yep. So not only does she have the original probate proceeding so that she can administer his estate, now she, the biological mother of those children, has to file in the probate court to ask the court to appoint her as guardian of their estate. So that's 3, however many kids you got, that's a probate plus a guardianship for each child so that you can receive those funds, and then the court has to tell you that you can use them.
Yep.
So
we have a traditional family, husband and wife with all kids of the marriage. In this scenario, the husband has passed away, the wife has survived, funds are going to a minor child, but because it's a minor, they can't. So now the biological mom of that child has to go to court to actually receive those funds, and then has court involvement and disbursement of those funds.
Right, and you can see how this would easily turn much more horrific if there were any sort of contested or, the family dynamics. Let's say that you're no longer married to this person. And so that's why you've listed your minor children as the beneficiaries, because you've been divorced. Well, if you list those minor kids, guess who's going to manage that for them when they apply to the court to become the guardian? Probably your ex-wife,
that's
but
right.
You probably don't want to manage those funds.
People spend all that time and money getting away from their ex, set the funds aside for their children, and then they pass away, and that same ex they attempted to run away from suddenly comes galloping back into the picture.
Yeah.
So
what are the other solutions that sometimes people do that are wrong? We'll give you the right ones, but the wrong ones are listing a different beneficiary. So I want my sister to administer funds for my 2 kids that are minor, so I'm going to list her as the life insurance beneficiary. How does that go wrong, Chris?
Yeah, right. Sister's great. She's wonderful. She's reliable, and that's why you're naming her. But lo and behold, she gets in a car wreck, and she's negligent, and she's being sued. And those funds that you named her to receive, even though they're meant for someone else, they're still hers, and suddenly her liability is your problem, or is your assets problem. So you may have a named beneficiary who's living a lifestyle or making decisions or involved in an action that puts those assets at risk. Of course, the other problem could be if you just leave it to your sister, it's hers. She can do with what she wants. She may have had the best intentions. Those change over time. What if y'all had a falling out? You never go back and change that? And she's thinking, wow, thanks for all that money. I mean, these things happen. So she could be party to a suit. She could be disabled herself. What if she was to pass away? You leave her something and the expectation goes back to your kids, but instead she then passes away. Well, guess what? her beneficiaries, her will control where those assets go.
Absolutely.
I mean, we've seen some great families have some very unexpected problems, and those funds just go away.
Even if sister is the best person in the world and will carry out your wishes, it's unfair, in my opinion, to have set it up that way. Because one, if she receives $100,000 and starts giving out to those kids, that's her gifting to those kids. That has legal and taxable implications for her own estate plan and her own family. And if that happens to be a retirement account that you've left her the beneficiary of, that's going to be ordinary taxable income to her as she pulls it out. It's wildly unfair to ask her to pay taxes on that ordinary income, then turn around and use it for minor beneficiaries or hold for them. It's just impacting her. Even if she's great and she's going to do the right thing, it's impacting her in a way that's really unfair to ask.
Yep. Dangerous, that one's dangerous.
Yeah,
Okay,
absolutely.
other bad solutions.
Well, just so listing nobody if you don't have your estate plan done.
Yeah.
So you don't want to list a minor. You don't want to list another person that you intend to use for the minor. And then listing no beneficiary may be the right answer, but only if you have your estate plan done correctly to provide for what happens. But as we say in all these videos, for every single person, you should understand and have a list of, okay, I have a 401k, who are the beneficiaries? I have a life insurance, who are the beneficiaries? I have a bank account, who are the beneficiaries, or how will this go to somebody upon my death? And on all of those things, we don't want to list a minor beneficiary.
Yep.
Now, even on the things that don't list a beneficiary, if you have minor kids, you need to think through what would happen with assets that don't list a beneficiary. So your house, your car, your personal property belongings, those, even though you've not written them, have beneficiaries designated through Texas law if you've not taken the opportunity to have a will put in place. And again, the existence of the minor who cannot receive property, real property, cash, life insurance, can't own any of it, them being a beneficiary of those things is very problematic.
That's right. You don't write a will. Texas writes one for you. It may not be what you want, but that's what will happen. And once again, if your children are minors, they would inherit, and then the same problem is created all over again. So you at least need to have, at a minimum, a will set up to catch these unthought of assets or these unplanned for assets. And in the will itself, we can take care of issues. And I guess that leads to my question. So my next question, we've seen all sorts of problems and then wrong solutions to the problem. What is a better or right solution to this problem?
Absolutely. Trying to make sure that our video is still working. I think so. It's hard to say.
Not looking good.
We haven't done this in a while, so we kind of forgot how. But anyway, glad to be here. So, right. But the clock's still going?
Did you put bubbles on me?
I don't know.
There's bubbles.
Anyway, hopefully this is still working. So the right solution would be talking to probably your spouse, if not your spouse, whoever you're going to, talk to about these things. You need to, if you have minor kids, consider first, this is not about money, but who will be the guardian for those kids. If you and the other biological parent for the child passed away, who do you want to physically raise those kids? That's going to be designated as the guardian of the person of those kids. So if they were orphans, who's going to take them in and physically raise them? That's very important.
Yep.
That's a hard one to reach consensus on, and you should really, ideally, pick the same person because you would just be setting that up for conflict if you pick different people.
Yep.
And then number two is in your will or estate plan of some kind, you need to have created, and these can be testamentary trust, which just means created in your will, but your will would say, I leave everything, or whatever you want, in equal shares to my children, if both me and my spouse are gone, in trust until a certain age, most commonly 25 or 30, but you can pick any age that you want. And then you get to designate who would be the trustee of those trusts.
Obviously not you or your spouse, because you'd be deceased,
Right.
for this to ever happen. This is where the next consensus point needs to be. Would that be the same person you named as guardian? May it be someone different? Yeah, maybe you're like, my parents can do it, but they're getting older, so maybe you list your parents, but then you have backups, adult siblings or mature friends, people who share your values and how you raise kids. I mean, my wife and I have talked about this. I know you and your husband. These are tough conversations,
Absolutely.
but it beats a blank piece of paper with everyone staring at each other in probate court.
Yep, absolutely. It's important that you have those conversations and that you make those decisions, and really even just for the peace of mind of knowing if something had happened to you, I have provided, hopefully, some life insurance, some whatever for those kids so that you can know even if something happened to you, my kids will be provided for. I know who will raise them. I know who will manage their money. I know that their future will be okay because I have set these things in place.
Yeah.
So it is, yeah.
Versus the mom and dad have just both passed away. No one's quite sure who's in charge. No one's sure where the money's going. And now we're going down to the court for the next 90 days or so to try to sort out at least a temporary plan. Not pleasant.
No, very unpleasant and so easily avoided if you would just make those decisions. And really what you probably should put into place as a young person is a will. Yeah. Because hopefully you won't die for many decades. Your kids will be adults. You can then list them as beneficiaries on things once they are legal adults. But until that time, you need testamentary trusts for them that can appoint a trustee that will manage for those kids. And typically on those trusts, you can pick different standards, but typically the trustee would be providing for their health, education, maintenance, or support. So it's not that the child doesn't have access to those funds until they're age 25. They're in trust with a trusted person paying bills for them. So it's not, hey, 18-year-old, here's $1 million and you're going to blow that. It's here, sister, who is a trusted person who is serving as trustee for that 18-year-old, is going to buy them not a brand new Ferrari, going to make sure they pay for school and have a place to live and that they have health insurance so that somebody that is an adult is providing for that beneficiary just like if you were alive.
And if there's sufficient assets or just a lack of options, there's also always the ability to hire professionals. You can start looking at some of the local banks. They have trustees departments and things like that. They'll help you as well if you're worried about not being done professionally.
Yep, absolutely. If you have no person that is appropriate to serve in that role, you can list an individual. You can also list a corporate fiduciary, which is often the bank that you use locally. So those are great options, especially considering it might be an extended period of time that they would be serving there. And I did also want to mention that this talk is for minors, but it applies to a disabled adult as well. Everything we've just said applies to a disabled adult. They should not be listed as a beneficiary. They do need a trust with somebody set up to manage for them.
And one thing I just want to point out too, Kristen, you said, hey, your plans basically may be one thing when you're age 30 or 35. They may be different than when you're 50 or 55. Sometimes you need more protection. Sometimes you need less protection. A lot depends on what the age of your children are, maturity level, what you own, where you're at, whether you're divorced or single. So what our answers may be now could very well change. I've had people before set all this up. Then their children were great 22-year-olds or great 25-year-olds. Undo it all, simply leave it to the kids outright. And now they're getting older to have grandkids, and so now we're planning all over again. I mean, unfortunately, when it comes to estate planning, the answer today can very well be different, which is why that list Kristen was talking about, a list of your assets, knowing where it's going and who and when, is so important because your answers could change over time.
Absolutely. And an important reminder to just look at that estate plan every year.
Yeah.
I would say during tax time, pull it out, look at it, make sure it's correct. Any major life event, you pass away, your spouse passes away, your child passes away. Anytime somebody dies, you change a job, you have a new child, grandchild, those are appropriate times to pull out your estate plan and decide, are changes needed? There may not be, but
I've seen life insurances pulled out, and the couple was divorced 40 years ago and still lists an ex-spouse. So things to correct.
Important things to get done. That's right. Okay, no idea if this video worked, but anyway, thank you for being here with us.
Maybe.
Hopefully this worked. We'll see you next time.
There are bubbles on my face.
I don't know what that is.